Thank you everyone for joining us in the afternoon. We're pleased to have Dr. Tian Yuan from the National University of Singapore to share with us her research on late imperial Chinese history this afternoon. I will just introduce the speaker briefly and I will let her speak. So Dr. Tian Yuan is a historian specializing in late imperial and modern China with a focus on legal history, business history, Christianity, and colonialism. She obtained her PhD from the University of Chicago and her MA from Stanford University and her bachelor's degree from here, University of Hong Kong. So she's back home. So currently she's working on her monograph on charted jurisdiction, law, imperialism, and global trade in modern China, which investigates how extraterritoriality, which is the topic this afternoon, a colonial legal framework granting foreigners immunity from Chinese jurisdiction, became deeply embedded in the legal and social economic fabric of Chinese society. This project shifts scholarly attention from the well-studied coastal treaty ports to the Chinese interior, particularly the Upper Yangtze region, offering a fresh perspective on imperial legal encounters and Sino-foreign trade. Her recent work will be published in Late Imperial China and Journal of Chinese History. Yuan's research has been supported by grants and fellowships from the American Council of Learned Societies, the Hoover Institution, the Association for Asian Studies, and the Nichols Center for British Studies, and the China Times Cultural Foundation, among others. So let's welcome Dr. Tian Yuan.
Thank you very much for the introduction, and thank you so much for having me here, and for everyone to be here with me. And also a special thanks goes to Greg and Gary for arranging the details of this talk, design the posters and all the technology today. So today, I will explore how Christianity and extraterritoriality together played a central role in reshaping the local judicial landscape in late China, and my geographical focus will be Sichuan, a province in southwest China. So in the 1860s, officials in Sichuan encountered serious challenges in administering justice due to French Catholic missionaries' interference in lawsuits involving their Chinese parishioners. And the core of this predicament lay in extraterritoriality, which is a colonial legal regime established after the Opium War and granted foreigners the immunity from Chinese law. Although the Nanjing Treaties only granted this privilege to Westerners, local courtrooms in China increasingly witnessed foreigners meddling with judicial proceedings of lawsuits involving Chinese only, and by having consuls file and intervene in their cases. And this issue was further compounded by Chinese people with even tenuous connections to foreigners actively seeking legal protection under the extraterritorial regime. So this situation led to new complexities in how justice was administered in local society. While extraterritoriality has often been studied in coastal regions like Shanghai and Hong Kong, where colonial presence was robust, Sichuan presents a distinct case. This province, located deep in the Chinese interior, faced numerous challenges on foreign activities, making it an unlikely site for the kind of colonial legal regimes found in the more heavily influenced coastal cities. And in this context, I aim to explore two central questions. First, how did extraterritoriality function in non-coastal areas lacking colonial institutions like the Shanghai Mixed Court or the British Supreme Court? And what did extraterritoriality look like from within the Chinese courtroom, particularly in terms of its social implications and its interactions within the Chinese courtroom with the local Chinese justice system? So the presence of extraterritoriality in local society is often examined through the lens of ZHOU or Christian cases, which helps explain the violent reactions to Christianity in late China. So scholars such as Boqun had argued that Catholic missionaries defending their Chinese converts in lawsuits had undermined the traditional authority of Chinese gentry in dispute resolution, thus fostering hostility toward Christian churches. And similarly, Joseph Esherick has noted that by extending extraterritorial protection to Chinese converts, Catholic missionaries in Shandong essentially established the Catholic Church as an imperium in imperial, a power within a power, which contributed to the backlash against Christianity, including the Boxers' uprisings. However, while violence is a crucial aspect of understanding how extraterritoriality operates in local society, it should not be seen as a default response. Instead, my research draws on judicial records from the Ba County archives, which is the largest known local archives from the Qing dynasty, to examine how Chinese actors strategically employed extraterritoriality. In particular, I show that local communities generally responded through non-violent means to extraterritoriality by negotiating their positions within a new legal world shaped by the increasing foreign presence in local society. Furthermore, I argue that grassroots officials such as magistrates, while wary of foreign influence, tacitly tolerated foreign interventions in local courtrooms to avoid escalating diplomatic tensions. In this way, both Chinese and foreign actors consciously shaped extraterritoriality, integrating it into the fabric of local justice in late 19th century Sichuan. So, as we explore these interactions, we must first understand the historical backdrop that lead to the legal entanglements surrounding Christianity and extraterritoriality. So in May 1805, the ZHOU Emperor issued an edict to suppress Catholicism, which was prompted by the circulation of a Christian manual that described the Manchu prince being dragged to hell for his injustice, only to be saved by his wife's Christian virtue. While the Judging Emperor seemed dismayed by European missionaries, defying the Yongzheng Emperor's 1727 prohibition on Christianity to continue preaching, the edict reflected his deeper concerns and anxieties about the threats that unorthodox beliefs pose to Manchu rule. So beyond Beijing, the campaign found its epicenter in Sichuan. In June 1805, the governor of Sichuan, De Lentai, launched an extensive search for European missionaries hidden in the province. By the late 18th century, Sichuan had become a haven for Catholics fleeing persecutions in Beijing and the coastal regions. The province's geographic remoteness and a significant presence of migrants in its population fostered a stranger society, which then provided an environment conducive to sheltering missionaries and converts. And among the most prominent Catholic mission in Sichuan was the Foreign Mission Society of Paris. And despite sporadic persecutions, the number of baptized Catholics continued to increase in the province. And by the end of Qing Dynasty in 1911, Sichuan alone counted more than 110,000 Chinese Catholics. So on the legislative front, in 1811, a sub-statute was added to the Great Qing Code, 大清律例, under the statute prohibiting the practice of witchcraft, 禁施巫邪术, and targeting European missionaries and their followers. This law stipulated immediate execution by strangulation for those found printing religious texts, organizing secret congregations, or preaching. And civilian Chinese converts who refused to recant were exiled to servitude in Xinjiang, and bannermen converts were stripped of their banner status. Those willing to renounce Catholicism to avoid prosecution were required to perform a public renunciation and trampling on a wooden cross in public. However, people who reverted to their faith incurred additional penalties. And this sub-statute typified the broader campaign's blend of terror and leniency, aiming less at mass executions than at deterring people from practicing Christianity. So officials in Sichuan recruited recanting Catholics, particularly those who were eloquent, and sponsored them to persuade other people to abandon the faith. And by 1817, more than 3,000 Catholic households in Sichuan had complied with official demands and renounced their religion. Yet those who resisted endured harsh punishments, from exile to Xinjiang to death sentences. And the campaign reached a dramatic climax with the public beheading of a French missionary to France in September 1815. His unyielding adherence to Christian doctrine, even under torture, led to the sentence of immediate execution by beheading. He was taken to the bustling marketplace of Chengdu, which is the provincial capital, and executed in full view of his followers. Afterward, the officials ordered his severed head to be paraded throughout the province. as a deterrent to other believers. And beyond the courtroom, community members in Sichuan were mobilized in a systematic hunt for Catholics. The government ordered community leaders to conduct house-to-house searches, while village notables identified believers and compelled them to sign statements of apostasy. Magistrates then praised those who had already recanted, publicly posting their names to encourage mutual surveillance. Community leaders faced collective liability if Catholic practice re-emerged in their jurisdictions. And the resulting atmosphere of suspicion fractured social relations with friends and family became potential political liabilities. And some sub-bureaucrats, such as rounders and clerks of the Yamen, exploited this precarious climate to extract bribes from converts who have already recanted. Although the judging emperor's main goal was to safeguard Manchu rule by rooting out what he perceived as unorthodox ideologies, this campaign left a lasting impression on Western missionaries. Many believed that Chinese Christians were vulnerable under the Qing law. The sentiment was repeatedly voiced by missionaries during the 19th century, who described the torture and mistreatment inflicted upon converts during the Jiaqing Ring persecutions. So during the Nanjing Treaty negotiations after the Opium War, these episodes of persecution were cited as a major reason for missionaries to demand extraterritoriality. And later on, the 1858 Treaty of Tianjin granted missionaries the right to travel within the Chinese interior and acquire property there, which gave them more power. As Christian churches emerged as powerful institutions in Chinese society, Western missionaries invoking extraterritorial privileges and consular intervention actively intervened in lawsuits involving their converts, even when the disputes were exclusively between Chinese themselves. And supported by the threat of foreign military power, these interventions typically guaranteed favorable results for the Chinese converts and creating tensions between Christian and non-Christian communities. So by the early 1860s, the Qing state had noted increasing litigations involving Chinese Christians in areas with missionary presence. And officials blamed this trend on opportunists who had converted only to exploit missionaries' growing influence. So in 1865, Chongshi, who was the general of Chengdu, noted in a memorial, quote, long-standing believers now treat their faith as an amulet in Chinese Hufu, persistently escalating the smallest disputes to full-scale lawsuits. Others, fearing unfavorable verdicts, convert solely for judicial protection, convinced that magistrates remain powerless before bishops and priests who passionately defend their converts, unquote. And local gazetteers in Sichuan also echoed these official concerns. So for instance, the gazetteer of Guang'an prefect noted that bullies and thugs use Christian churches as an amulet, in Chinese, 以敬教为护符, seeking sanctuary after committing heinous crimes, resisting legal proceedings, or evading COVID labor. The Chinese term 护符 literally means a religious talisman, offering protection against misfortune. And figuratively, it signifies the strategic use of authority, status, or influence of a powerful party to secure protections. And this metaphor appears frequently in Boqun archives and official gentry discourse, where officials used it to describe Chinese Christians and Chinese employees of foreign companies who had leveraged their foreign connections for legal advantage. So historian Melissa Macaulay has noted that the Qing official legal ideology emphasized moral principles over litigations because litigations was seen as disruptive to social order. And official discourse in the Qing believed that social stability depended not on rigorous legal enforcement, but on moral consensus and harmonious relationships in the community. And as Melissa notes, quote, local elites, especially the good gentry who wrote gazetteers, believed themselves especially endowed with an ability to settle disputes and bestow harmony on the community, unquote. Thus, official criticism of Christians seeking extraterritorial protection reflected their own anxieties as extraterritoriality reconfigured legal authority in local societies. Besides Qing officials' condemnation of the abuse of extraterritoriality, Protestant missionaries in China also criticized how Catholic missionaries abused extraterritoriality. For instance, Omar Kilbourne, who was a Canadian Methodist missionary in Sichuan, he had noted in his memoir, quote, the Roman priests were therefore empowered to demand and receive special attention from the Chinese officials in a way they never had been able to do before. The ground taken by the Protestant missionaries was that such a relation was altogether contrary to the spirit of the gospel message, and that it would lead to abuses of such privileges on the part of our Christians. We shall always do much more harm than we can possibly do good by interfering in any way, whether personally or by allowing our names to be used in cases at law between Chinese and Chinese. And therefore, the principle of non-interference is strictly adhered to by all or practically all the Protestant missionaries throughout China. However, evidence from the Boqun archives belies Kilbourne's claim of Protestant non-interference. From 1819 to 1910, Protestant missionaries intervened at least 12 times on behalf of their Chinese converts in the Ba County. But in general, Protestant missionaries maintained a certain decorum in their interventions with Chinese courts. And although they also invoked consular intervention on behalf of their Chinese converts, they typically refrained from overtly pressuring magistrates or engaging in combative courtroom altercations. And by contrast, local gazetteers often register complaints about French Catholic missionaries' confrontational behavior in a courtroom. So, for example, in 1905, a French missionary stationed in Nanxi County, which is in southern Sichuan, he stormed into the yamen, smashing tea bowls and pounding the table while demanding the release of his parishioner who was accused of robbery. And missionaries' motives for defending their converts through extraterritoriality thus varied. For Catholics, it was both a means to retaliate for earlier persecutions and to consolidate their influence by attracting new converts. Protestant missionaries who arrived in Sichuan later in the 1870s also used extraterritoriality mainly to compete for converts with the already established Catholic missions. And a British merchant, Archibald Little, who had lived in Sichuan for many years, he had observed about this Catholic Protestant rivalry. He noted that every single town in Sichuan by the 1890s had competing Protestant and Catholic missions. So how did Chinese Christians in Sichuan first begin to leverage extraterritoriality to gain an edge in lawsuits? To explore this question, I will turn to a judicial case from the Ba County archives, which is one of the earliest documented instances of a foreign missionary directly intervening for a Chinese Christian. The case took place in 1862. Joseph de Flash, a French missionary serving as the bishop in eastern Sichuan, he filed a complaint with the Ba County Yamen on behalf of a 59-year-old tenant farmer named Zhang Zizhen. He was a Catholic. So Bishop de Flash claimed that three of Zhang's lineage nephews, along with several militia braves and the local Baojia leaders, had barged into Zhang's property while he was farming, seized his farming tools, and forbidden him to continue working because it was a militia training day when men of the village were required to attend drills rather than engage in farming. So according to the bishop, when Zhang Zizhen sought help from the militia heads, one of his nephews tied him to the lineage temple and extorted 2,000 cash from him, threatening to confiscate Zhang's ancestral property for the lineage trust unless he paid. The nephew also insisted Zhang publicly renounce his Catholic faith and host a feast for the community. Soon afterwards, Zhang reported the incident to his French priest, who then told the story to Bishop de Flash. And in his petition to the magistrate, Bishop de Flash believed that the militia drill was only an excuse used by non-Catholics in the village to bully Catholics. And he requested that the magistrate summon the accused to court for questioning. So, complying with the bishop's request, the magistrate soon convened a hearing. However, the plaintiff, Zhang Zizhen himself, did not show up. And 4 months later, the accused lodged their own counter-complaint, claiming that Zhang Zizhen had repeatedly evaded militia drills, held to defend Taiping rebels by relying on his church's growing power, in Chinese, 张一教释要. They maintained that they took away Zhang's farming tools not to extort money, but because Zhang had tried to assault them. And their story also revealed a critical point that the bishop had omitted. They denied confiscating Zhang's so-called ancestral property, noting that Zhang was only a tenant farmer with no real land to forfeit. So during the initial trial, Zhang remained absent, and Bishop de Flash acted as his proxy through written communication with the magistrate. 3 years later, by then the 62-year-old Zhang Zizhen filed his own complaint. He admitted fabricating the story about ancestral property, but insisted that he had been harassed by neighbors due to his faith. And he accused the neighbors of extorting 2,000 cash, taking away his farming tools, and forcing him to renounce Catholicism after he declined to join the militia drills. And although some of Zhang's statements might have been exaggerated to gain the magistrate's sympathy, his experience is consistent with the exclusion that Christians generally faced in society. By early 1860s, Christianity had been decriminalized, but Catholics still encountered hostility within their communities. And in Zhang's case, his nephews apparently felt no guilt in disregarding Confucian norms requiring respect for senior members, which implied that any typical authority Zhang might have held was undermined by his faith. So we have 3 different narratives in this case, and we cannot be entirely sure whose version is most accurate. And late Qing judicial records often contain partial truths or contradictions that make it difficult for historians to ascertain objective facts or whether verdicts were fair. However, the key to this case lies not in declaring who was right or wrong, but in examining the social strengths, judicial procedures, and the shifting power relations between Christians and non-Christians during the 1860s. So as I said, the case occurred in 1862, which was right after the signing of the Sino-French Beijing Treaty in 1860s. And this period witnessed rising French Catholic influence in China. The Beijing Treaty enabled Catholic missionaries to reassert claims to lands allegedly seized during earlier persecutions. And in Guizhou and Sichuan, some Catholic missionaries began traveling in 4-carrier purple sedan chairs, which was a privilege reserved for Chinese officials only. And their growing influence, sustained by extraterritorial privileges, and when needed, the possibility of French military force intensified local resentment toward Christianity. So within this charged environment, tenant farmers like Zhang Zizhen found themselves encouraged and even emboldened to forego customary obligations such as militia drills. And in earlier decades, prudence and compliance had been vital for Chinese Catholics wary of persecution. But by the early 1860s, the growing influence of Catholic Church in China, particularly the privilege of extraterritoriality, had given Chinese Catholics a new sense of security. Zhang Zizhen's decision to ignore the malicious demands reflected a meaningful shift. He began to openly align himself with a church that offered him legal shelter, rather than complying with a lineage that had excluded him. Moreover, Zhang Zizhen's Catholic identity allowed him to circumvent the normal bureaucratic hurdles of filing a complaint and waiting for the magistrate's approval, a process often fraught with uncertainty in the Qing dynasty. As historian Philip Huang notes, Qing magistrates would sometimes summarily dismiss petitions or deem that the matter was too minor for him to handle personally and remind the case to lesser lights. Yet Zhang Zizhen bypassed this path by contacting his French priest, who then elevated the matter to Bishop de Flache. The bishop reached out to Magistrate Zhang directly, bypassing standard protocol and ensuring the complaint would be addressed. Meanwhile, those accused of wrongdoing, despite their presumably stronger local standing, had to submit petitions through official channels and were initially rejected. So in Leiqing Sichuan, this pattern of actual legal recourse, where Chinese converts pressed charges via missionary intermediaries, would grow increasingly frequent. Chinese associated with foreigners, such as Chinese Christians or Chinese employees of foreign companies, would gain streamlined access to official ears, while local authorities had to tread carefully to avoid provoking diplomatic conflicts. As the 1862 case reveals, such interventions blurred the boundaries between Chinese lawsuits and foreign affairs, granting Christian converts a new advantage in legal proceedings. And Chinese Catholics like Zhang Zizhen found that turning to missionaries offered a powerful alternative to the uncertain outcomes of conventional litigation. And this shift foreshadowed in the emergent pattern in which extraterritoriality became deeply embedded in everyday judicial practices, a dynamic would define the legal culture of Leiqing Sichuan for the decades to come. So in the previous case, Zhang Zizhen was marginalized by his lineage, partly due to his faith, which made the bishop's intervention appear consistent with extraterritoriality's original intention, which is to protect Chinese Christians from persecutions based on their faith. However, as time passed, extraterritoriality began to be used for reasons that went beyond religious concerns. And here's another case that took place in 1867. So the Chen family in Tianping village, which was a village in northern Sichuan, the family reported a theft of 298 taels of silver to the local authorities. And by 1868, a year later, the village headman, Pan, he had identified two Catholic converts, Li Shusan and Zhang Bintang, as the culprits. So the Chen family moved forward with a lawsuit against the Catholics based on village chief Pan's findings. And seeking revenge, Li Shushan, one of the Catholics, instructed his brother to lodge a false complaint accusing village head Pan of harboring a White Lotus fugitive, thereby transforming a straightforward theft case into a matter of imperial concern. So the local magistrate, Prefect Shen Yi, had to open a formal court hearing for this case, but only to discover later that Li Shuzan's accusation was fabricated to distract attention from his own crime. However, the magistrate handed Li Shuzan only a mild sentence, suggesting him relocate to a different place to diffuse tensions with villagers in Tianping. While Magistrate Shen officially attributed this leniency to Li Shu's status as a degree holder, it is more likely that he wished to avoid sparking Catholic intervention from these missionaries, which would prolong and complicate the case. So the magistrate's fears soon proved valid. The other Catholic suspect, Zhang Bingtang, who was absent from the earlier hearings, informed his French priest that the village had possessed anti-Christian pamphlets, this is also an act of retaliation. Although the priest withdrew his petition when the magistrate showed these allegations to be groundless, Zhang and Li continued to press charges at higher administrative units from the Chongqing Prefectural Yamen to the East Sichuan Circuit Yamen. And they also threatened to bring the case to a French bishop's attention if they were not heard at the local governments. And this sequence of events unfolded against the backdrop of the Youyang anti-Christian incidents. So in 1865, a major anti-Christian outbreak in Youyang, which was located on the border of Sichuan and Guizhou, led to the destruction of a French church and the murder of a French missionary. And under French military pressure, the Qing government executed the culprits and paid 80,000 taels of silver in compensation to the French. However, in 1868, only 3 years later, another uprising took place again and claimed the life of another French missionary and also several Chinese Catholics. And in retaliation, armed Chinese Catholics destroyed non-Christian homes, killed over 145 non-converts. And again, due to the looming threat of French military intervention, the Qing government punished only the non-Christian assailants and paid an additional 30,000 taels of silver to the French as compensation. So adjudicating the case under such a precarious political climate, Magistrate Shen Yi had to weigh the risk of potential French reprisals when dealing with Li and Zhang's offenses. And the Tianping residents also recognized that this was a very sensitive moment. They feared that if the Catholics appealed to the bishop, it would lead to devastating consequences for them. So this case shows that within only 5 years of the Zhang Zizhen's case, the judicial savvy of Catholic converts had enhanced significantly by filing petitions, making forced charges, and enlisting missionary intervention. They seized upon the leverage extraterritoriality had conferred, showing a growing awareness of how to manipulate the legal system to their own ends. So by the late 19th century, word has spread throughout Sichuan that lawsuits mediated by foreign missionaries proceeded quickly and often guaranteed favorable results. And rather than submitting a plaint to the Yamen through formal channel, missionaries simply wrote to the magistrate to file suits on the plaintiff's behalf. And often, in these cases, plaintiffs neither appeared in court nor faced cross-examination. These were privileges highly desired in a society where ordinary people had very limited access to the court and very limited judicial resources. So this expedited and successful judicial outcomes attracted many people to convert to Christianity. And in Jianyang County, which is a place near Chengdu, a Chinese Catholic named Zhang Youzhi, she recalled how a French missionary amassed considerable influence after he arrived in the county in 1905. So here is a paragraph from his memoir. She noted, because Coran, which is the French missionary, represents a powerful foreign nation newly appointed magistrates usually paid him courtesy visits, and he reciprocated by maintaining amicable ties with them. Their mutual support bolstered each other's sphere of authority. Courant, who had his own teeth and tenants in Chinese ZHOU within the Yamen, became the first intermediary for locals dealing with the government. People fearing predatory officials or powerful gentry turned to the church for protection. An act described by the locals as borrowing a house to shelter from the rain in Chinese 借房子躲雨. And even local bandits viewed the church as a protective talisman. So according to the local gazetteer of Jianyang, after missionary Courant's advocacy freed a convicted convert from a death sentence, about 300 people converted immediately to Christianity. So not all of the people who sought the church's protection wanted to convert, of course. And in such instances, Chinese converts became intermediaries, extending extraterritorial protection to those without direct connections to foreign missionaries. And they do this for a price. So the story of Yuan Maoshan, who was a Chinese Catholic from Lezhi County in central Sichuan, is a telling example. So Yuan was the headman of the local Catholic church, and he opened a shop adjacent to the church. Although the shop nominally sold basic goods, it actually offered legal services for people who are in need. So for 7,000 cash, Yuan secured favorable verdicts for anyone, Christian or not, and his business flourished and earned Yuan and the church considerable cash. One of his neighbors reported, as long as the litigant bribed Yuan, Yuan not only intimidated the county magistrate into rendering judgments according to his wishes, but also Yuan regarded the courtroom as his domain, behaving as though he were the magistrate's equal. The magistrates all indulged him for the sake of maintaining peace with the Catholic Church. And a local source compared Yuan to a fox borrowing the tiger's might, referencing a Chinese idiom from the 战国策. So the source noted, Yuan sold his soul and became a fox, executing foreigners' tasks. In truth, he wielded the tiger's might to frighten his foes. In Yuan Maoshan's case, we see how extraterritoriality infiltrated the everyday lives of ordinary Chinese. And although Yuan himself did not have formal extraterritorial status as the foreigners did, he wielded the indirect influence of extraterritoriality and served as a conduit to match community needs with foreign advocacy and protection. So the presence of Christian churches and extraterritoriality not only reconfigured judicial norms and power relations in local society, but also reshaped the criteria by which magistrates and community leaders decided which disputes warranted formal adjudication. In this context, the direct and indirect influence of extraterritoriality altered what historian Philip Huang describes as the third realm of justice. To begin, it is useful to outline Philip Huang's concept of the third realm of justice. So in Qing Dynasty, there were generally two recognized domains for dispute resolution. First, we have the realm of grassroots mediation, where family heads, lineage elders, local notables, or guild masters would intervene to settle disagreements informally. And second, we have the realm of formal judicial proceedings at the courtroom, presided over by a magistrate who could impose punishments in accordance with the Qing Code. And between these two realms, however, Huang argues that there existed a third realm of justice where certain cases, particularly civil or minor disputes, were handled by local figures working together with or under loose directives from official authorities. And this included Yamen runners, clerks, or community intermediaries who gathered evidence, assessed testimonies, and proposed settlements. While magistrates technically oversaw these processes, in practice, they often let local actors to take the lead, intervening only when such efforts failed or when the dispute escalated in severity. So from a practical standpoint, such reliance on local intermediaries was very important and indispensable. The Qing bureaucracy was relatively small, especially given the population growth and commercialization that occurred from the 18th century onward. So magistrates were burdened with enormous caseloads, and they routinely look for ways to reduce direct involvement in minor disputes and encourage the disputants to resolve matters privately or through local mediation. Moreover, the Qing official ideology disliked litigations and perceived it as a sign of moral decay. So magistrates often worry that frequent lawsuits would reflect poorly on both local governance and the moral order of a certain locality. So as a result, some petitions would be summarily rejected, forcing would-be litigants to turn to private intermediaries, such as litigation masters, in Chinese, 讼师. This is like an equivalent of current-day lawyers in late imperial China. So scholars like, Melissa Macaulay have argued that these litigation masters, though officially condemned, were typically educated people, and they're often degree holders who understood the nuances of Qing legal procedures. They sold their expertise to those who struggled with drafting petitions or navigating the judicial procedures, and thus forming an essential link between common people and the court system. And even though the Qing Code banned both the hiring of litigation masters and magistrates delegating dispute resolution to local actors, these practices continued unabated because they served everyone's interests. The magistrate's interest in reducing his workload, the litigant's interest in competent representation in court, and the local community's interest in maintaining order outside the formal legal process. So the Qing state's anxiety about non-state legal intermediaries did not prevent grassroots officials from relying on them to keep the wheels of local justice turning. So in essence, the third wheel made it possible to solve most routine or small-scale disputes without fully engaging a formal judicial apparatus. However, the mid-19th century brought new complications to this carefully balanced judicial dynamics. Foreign influence over Chinese justice began to rise due to the treaties signed after the Opium Wars, as well as the expansion of Christian mission into China. The extraterritorial privileges conferred by these treaties granted foreigners immunity from Chinese legal jurisdiction. While these privileges were only supposed to be enjoyed by foreigners, missionaries often in practice extended them to their Chinese converts. And as a result, Chinese Christians could often bypass many of the bureaucratic hurdles in filing lawsuits by appealing directly to foreign missionaries and foreign consuls, who in turn would pressure the Chinese magistrates to rule in their favor. And in Qing official ideology, this phenomenon was condemned as filing lawsuits by proxy, in Chinese 包揽词讼. So before the mid-19th century, Qing officials used this phrase to criticize Chinese litigation masters who sold their services to litigants in petition writing and legal strategy, thereby undermining what the state considered proper judicial procedures. However, by the late 19th century, the same term was frequently applied to foreign missionaries or foreign consuls who intervened in Chinese legal matters and who compelled magistrates to convene hearings without following normal channels. As an official in Shandong had described it in his report during the Boxers uprising, he noted missionaries serve as litigation proxies for their converts, 教士为教民包揽词讼, who do not submit formal complaints. A simple letter from the missionary compels local officials to issue warrants summoning the accused. So from the perspective of Qing's state, foreigners thus presented a new and far more disruptive category of non-state legal intermediary than the traditional litigation masters. Whereas Chinese litigation masters charged fees for their legal service, missionaries and consuls were often driven by more complicated reasons to take Chinese under the extraterritorial protection. Some of them genuinely believed that without their protection, Chinese Christians risked injustice at the hands of prejudiced or incompetent magistrates. Others have pragmatic interests in extending extraterritoriality to Chinese. Over time, the balance of power shifted in the third realm of justice, and no longer were Chinese litigants restricted to community mediation or reliance on a potentially indifferent magistrate. They could now enlist foreign support to expedite their complaints or to secure preferential treatment. As a result, the third realm of justice, once managed primarily by local elites, was increasingly open to foreign influence. And in turn, local elites, a term that might include lineage holders, gentry, or other leadership figures in local society, they had to confront the reality that their customary influence over dispute resolution could be undermined. So, in the framework of ZHOU studies, Boqun and Joseph Escherick believe that this disruption of local elites' power in dispute resolution would invariably lead to violence against Christianity. However, a case from the Ba County shows that local elites did not always resort to violence when facing such challenges. Instead, they learned to adapt their dispute resolution methods in response to the growing influence of Christianity and extraterritoriality. So in 1909, several community leaders filed a plaint at the Ba County Yamen concerning a man named Dong. So Dong was accused of multiple thefts at the ZHOU chapel in Chongqing. So Dong had worked for 4 years at the chapel, farming and cooking, but he had not converted to Catholicism, so he was not a convert. And over the previous year, a number of items had gone missing from the chapel. And when a Chinese Catholic named Yuan, who handled certain administrative duties at the chapel, saw Dong taking a bowl of rice wine from the kitchen, he concluded that Dong must be the culprit behind all the recent thefts. So Yang turned Dong over to the community leaders, insisting that the matter be brought to the court. However, the community leaders found no conclusive evidence linking Dong to the earlier thefts. And in a typical scenario, such an absence of proof might lead the community leaders to mediate quietly, perhaps requiring restitution or some modest penalty. And the community leaders in this case all agreed that Dong's error could be resolved locally, noting that the petty act of taking a bowl of rice wine did not justify official intervention. However, Yang, the Chinese Catholic, insisted on pressing official charges against Dong. So consequently, the community leaders petitioned to the magistrate, despite they consider the matter to be trivial. So when the case reached the court, Dong admitted to taking the wine, the bowl of rice wine, but he argued that he did so to help a fellow worker named Yu, who was sick, and asked him for a bowl of rice wine. And Dong said that Yang had harbored a grudge against him, and thus interpreted his act of kindness as theft. So after hearing Dong's explanation, the magistrate decided to punish him lightly and release him. and not to charge him for the previous thefts. So in doing so, the magistrate apparently acknowledged that the community leader's initial assessment that there was no compelling evidence linking Dong to the previous thefts. So this episode highlights a telling shift. The only reason the case went to the court hearing was because Yang, a Chinese Catholic, holding some power in the chapel, insisted on official adjudication. And in earlier decades, community leaders would have felt secure resolving such a matter through mediation outside the court. However, by 1909, community leaders had become more cautious, recognizing that outright resistance to Christian demands would lead to larger diplomatic or political complications. So to avoid being perceived as obstructing Christian interests, these community leaders complied with the Chinese Catholics' demand to elevate a minor dispute to court hearing. And the result is that magistrates' docket became filled with minor disputes involving Chinese converts, disputes that under other circumstances would have been deemed too small for formal court proceedings and relegated to the third realm of justice. So as Philip Huang points out, the Qing law nominally forbade magistrates from assigning trivial matters to local intermediaries. Yet that was precisely how the system usually worked in practice, especially in populous regions like the Ba County. And research by historian Bradley Reed also shows that late Qing magistrates often relied heavily on local actors to reduce their administrative burden. But ironically, the fear of offending missionaries and foreign consuls pressured some magistrates to follow the Qing law more strictly in cases involving Chinese Christians. And when a Chinese Christian filed a petition, the magistrate had little choice but to accept, even if it was a case that they might otherwise have dismissed. And in contrast, non-Christian litigants who did not have foreign support often saw their petitions rejected or delayed, a disparity that partly explains why some people embraced Christianity as a means of enhancing their position in lawsuits. So here's another case. In July 1895, Bishop Laurent Blattery informed the Ba County magistrate of an alleged conspiracy against the local Catholic Church. So two Chinese Catholics claimed that Qiu and Ling, who were residents of Chongqing's Shitanchang neighborhood, they were planning to gather armed bandits to attack the church. And the two Catholics also accused the local community leaders of extorting 2,000 cash from them, supposedly used to pacify the bandits and prevent trouble. And due to the politically sensitive nature of this case, the magistrate dispatched 30 staff to investigate. He instructed the staff to arrest the suspects if the claims were credible, and warning that any staff who hindered the investigation process would face serious consequences. The magistrate also issued a proclamation urging the local community leaders to cooperate with the investigation and remain vigilant. He wrote in the proclamation to the community leaders, "You are all people with families and social standing, and you cannot afford to bear such serious consequences." In Chinese, 尔等各有身家，恐难当此重咎也. So the magistrate's vigilance was driven by the political turbulence following China's defeat in the Sino-Japanese War in May 1895. And in Chengdu, the provincial capital, a public demonstration near a Protestant church condemning perceived British tolerance of Japanese expansionism had escalated into anti-Christian riots across the province. So 10 days later, the chief Yamen runner reported back that the accusations were unfounded. The so-called bandits in question were actually vagrants who recently arrived in Chongqing from elsewhere. And far from conspiring against the church, Qiu and Ling were upstanding figures in the community. And fearing unrest after the Chengdu riots, the local community leaders had approached these vagrants and ordered them to leave. So to expedite their departure, the local notables had raised 2,000 cash to prevent any possibility of trouble. Although the investigation revealed that it was the two Chinese Catholics who had made false accusations, the magistrate, keenly aware of the ongoing anti-Christian tensions in Sichuan, chose to maintain order rather than punish the rumor mongers. And in his letter to Bishop Laffery, the magistrate did not suggest any penalty for the two Chinese Catholics who had made false accusations. Instead, he assured the bishop that no anti-Christian conspiracy was underway and promised that local people would remain vigilant to protect the church. So apparently, the magistrate's priority was preventing unrest rather than vindicating the local notables who had been wrongly implicated. Once the matter was resolved, Zhang, the chief community leader of this neighborhood, he requested the magistrate's permission to promote ZHOU, who was wrongly implicated in the case, into a parallel leadership role in the community. So Zhang explained that one of the Catholics actually had attempted to extort 60 taels of silver from ZHOU during the investigation. However, Zhang did not go further into this misconduct, and instead he emphasized Shitanchang, the neighborhood's location on the Guizhou-Chongqing border, and the looming threat of famine-driven vagrants or bandits entering the area. And according to Zhang, ZHOU's wealth, moral standing, and familiarity with local affairs made him ideal for a leadership position in the community. So the magistrate acknowledged the community leader's hard work in the previous investigation. However, he did not immediately endorse ZHOU's appointment. The magistrate's hesitance underscores the delicate position occupied by grassroots officials. The immediate promotion of ZHOU to community leadership would have implicitly admit that the local notables had been wronged by the Catholics, and that the magistrate himself had overreacted by threatening the community leaders previously. And more important, aligning too closely with ZHOU risked antagonizing the Catholic Church, whose favor the magistrate depended on to help maintain broader social stability. So as Christian churches became more powerful in local society, local elites found themselves in an increasingly constrained position, yet they learned to maneuver within this new order. And by the late 19th century, anti-Christian violence across the country risked severe diplomatic repercussions. Thus, local elites in Sichuan often opted for accommodation rather than open confrontation. And the community leaders in Shitanchang perceived the forced charges against them not as a trigger for revenge, but as a leverage to negotiate with the magistrate to consolidate their position in the community. And in this way, some local elites walked a tightrope. They neither gave in to the church's growing power nor risked direct conflict. Instead, they tried to preserve their standing by tactfully negotiating with the new power landscape. So I have here are some concluding thoughts. I have examined the interactions between Christian churches and local communities around extraterritoriality in Leyqin, Sichuan to offer an alternative explanation to the narratives of anti-Christian riots. And Chinese Christians, once marginalized for their faith, capitalized on extraterritorial protections to secure legal advantages and sometimes commercialized these privileges for their own benefits. And meanwhile, non-Christians manipulated popular suspicions of Christian litigiousness to discredit the Chinese Christians. And under mounting foreign pressure, Qing officials adopted a more accommodating stance toward the intrusion of extraterritoriality into their jurisdiction. Meanwhile, local elites also negotiated with the extraterritorial regime to retain their authority instead of directly resorting to violence. And although Qing officials blamed the misuse of extraterritoriality on the moral characters of certain missionaries and Chinese Christians, I argue that the real attraction was the effectiveness of extraterritoriality in securing favorable judicial outcomes, a benefit that was sought by both Christians and non-Christians. And rather than simply dismissing these individuals as opportunists, their action reveal deeper problems in the late local justice systems. The appeal of extraterritoriality was so strong that it motivated religious conversion, suggesting that the traditional dispute resolution mechanism in Chinese society were inadequate to meet the growing litigation demands during the 19th century. And this led people to seek foreign advocacy through the extraterritorial regime alongside conventional local mediation methods. So ultimately, this study wanted to invite us to rethink the portrayals of extraterritoriality as merely provoking anti-Christian sentiment or undermining Qing sovereignty. And by positioning missionary interference in everyday lawsuits, we see how Chinese and foreigners alike wove extraterritoriality into local justice. So this is the end of my presentation. Thank you very much for your patience. Thank you very much.
Thank you, Dr. Tian, for your rich and inspiring talk. And there is a wealth of materials in the talk, and I believe there are a lot of things we can discuss further. So now let's open the floor to questions from the audience.
First question was, I was thinking with respect to the missionary, this ability to be able to sort of save someone from maybe an execution or serious punishment. If you were a missionary, that seems to be a very powerful way of saying this is why you should work. Right? So did missionaries explicitly use their increasing capacity to intervene in local? Do they explicitly say in sort of religious overtones, this is what Christianity can do for you, as a way of kind of convincing into conversion? And then the second thing was, I was really interested when you talked about the ways in which the intensifying or the deepening of extraterritoriality was changing the procedure in Qing law. And I was wondering whether judges were aware that if they sentenced very severely, that one case you said of where there was 300 conversions, I thought that was very, very powerful. And I was wondering whether there's any evidence that judges were maybe punishing more leniently because they were afraid that their severity would lead to these sort of episodes. So you see a sort of changing of judicial decision making, but as it's in sort of response to that.
Should I take more questions or should I respond? Okay. Yeah, thank you for the question. So the first question is whether the missionaries explicitly talk about, explicitly mention that they're using this protection to attract converts, right?
Yeah, to leverage to save someone from the sort of the scaffold or something as a sort of religious.
I mean, in earlier time, right after they gained extraterritoriality, they've used this rhetoric to convince people that, because they believed that earlier they believed that Chinese Christians actually were vulnerable under a Qing law, and they actually faced persecution because of their faith. So they would say explicitly that I'm using extraterritoriality to protect you, to save you, and they feel they were justified to do so. However, after 1860s, the congregation became more complicated. So there were the presence of opportunists who did not convert to Christianity because of the faith, but because of the pragmatic protection and other money, financial gain that this identity offered. So I think from 1860s, 70s onwards, missionaries tend to refrain from, using this rhetoric, at least in public. Yeah. So the second question, did magistrate adjudicate more leniently because of the missionaries' pressure? Yes, I think that's a general pattern. Whenever they whenever they adjudicate a case with involving Chinese Christians, and whenever they have a missionary intervening on behalf of the converts. The magistrate almost all the time, they almost all adjudicated more leniently in a way to prevent, in a way to avoid provoking the missionaries and the foreign consuls behind them. Yeah, that's like a general pattern.
Question online, so we will ask the Elaine for the ask. Is it muted? Mute?
Okay.
Is it muted? Can you hear me?
Yeah.
Yeah, please speak up. Yeah. All right.
Okay. So I would like to ask you a question. Thank you for your presentation. I was wondering if, like, in your sources, have you find any reflection of like involvement of the French state, of the French like governmental power in this litigation or legal process? I'm asking this question because I'm personally studying like Protestant mission, the Basel mission, which was mostly based in Guangdong. And as the Tianjin and also the Peking Treaty were put into power, they started to use the legal means to protect their congregation, mostly like Hakka people in the northeast Guangdong. And back then, they noticed that although the treaty did provide them with like legal means to protect their congregation, there was, for example, a case of basically Christians complaining that they were forced by local magistrate that in some non-Christian worship and celebrations, and they were like asking the missionary to protect them. But the missionary basically told, since they were a German-speaking Swiss mission, they very much were lacking any protection from their, like, power, and they had to appeal to British, mostly colonial power, to basically speed up the legal process. And I'm wondering if in your sources there is like some indication that the since, as you mentioned, the French Catholic Church not only was like the power coming from the Catholic Church, which was way more unified than the Protestant congregations, but also they had very, very precise, very narrow, basically governmental great power of France that very much favored Catholics over Protestants. Thank you.
Thank you very much. I think that's a very important question. So at this stage, I'm mostly looking at local Chinese sources, and some French sources that were translated into Chinese, mostly the correspondence between French missionaries. So I think to further understand the question you raised, I will have to look into French archives. And that would be my plan for the book manuscript. But at this stage, I still don't have, I still haven't visited French archives. And I think it's really interesting. The question is really interesting regarding the role of the French state in this, legal interactions. I mean, from the source I've read so far, I've only seen direct involvement of the French state in severe incidents, like incidents that was really violent, that there were French missionaries and many Chinese converts killed. In these scenarios, there was the involvement of the French state, for instance, French consul, and also, so there were a lot of state level negotiations between the Qing and France. But at the more local level, and for cases that does not involve severe violence or death, I don't see the direct involvement of French state. Instead, in these minor cases, the French state or French military power mostly appeared as a threat used by the French missionary and the Chinese Catholics. But they don't normally appear directly in court. I'm not sure if I have answered your question.
Yep, very much. Thank you. Thank you. Very,
Thank you
very,
for the question.
very like complimentary like answer. Thank you.
Thank you.
Great. Thank you for this wonderful talk. It's very rich and dense, and I have to admit, sometimes, I just couldn't follow. There were so many cases
Yeah.
as a literary scholar, but you also gave me a lot of ideas about how to read late Qing courtroom fictions, 晚清公案 or 谴责小说, right? So, but I do have some maybe quibbles with two major points. The very first is about the very notion of extraterritoriality itself. It seems that your intention was actually to tease out the nuance in how this term is actually in practice, perceived and implemented very differently at the bottom level. But I'm sure if I have read your article, I would have understood you much better. But I feel, given today's presentation, I didn't see that contestation and the notion of extraterritoriality is being, brought out fully. Rather, you are just presenting case studies over case studies. And it's almost in the sense that I feel like you agreed that there is extraterritoriality, extraterritoriality. And then it's taken as a given in this presentation. And then under that space created by this notion, and then you present to the case studies, but I don't see that very notion being used. And this is the first quibble. And the second quibble is about the very location of Sichuan itself. To me, it almost sounds like you at least presented, I think, 8, 9, 10 cases here. They could have happened in Shanghai and Beijing. I don't see that, the regionality, how the regional discourses really shines or need to be brought to the limelight. So in this sense, I'm a little bit worried that Sichuan is just being used as a background rather than a truly borderland that needs to be, restaged in our current field or repositioned in our current field. So we don't just look at Beijing and Shanghai. These are just the 2 points. So I'd like to hear your opinions.
I think these are 2 great points. And these are the points I will continue to explore in the book project. So the first question is about how I perceive extraterritoriality as a concept. I think, to be more precise, what I'm really interested in is the spillover effect of extraterritoriality. Not as the institution, because if it's an institution, you study in the mixed court, right? You study the British Supreme Court in Shanghai or in Hong Kong, and you study people who appeal to these colonial courts. But what I am interested in is how these interventions created extraterritorial regime within the Chinese local society, and also the rising importance of foreign consular courts in Chinese local society. So one way to think about is legal forum shopping, right? So you have so if there was no extraterritoriality, Chinese will have to go to Chinese courts to file their lawsuits. But with the presence of foreigners, such as missionaries and foreign merchants, who are willing to offer, consular protection to certain groups of Chinese, you create a different realm of justice in addition to the Chinese court system. And yeah, I think that's something I'm really interested to explore. And the second way to frame it is a legal pluralism, right? Because extraterritoriality itself is a kind of legal pluralism. And also the Qing Empire is a multi-state, multi-ethnic empire. It also has a long history of legal pluralism. And also, I'm really interested in how extraterritoriality as a legal pluralist regime interacted with the Qing Empire's own legal regime. So that's the 2 frameworks I am exploring extraterritoriality in my study. And the second question is also very important: the regionality of Sichuan. I talk about a lot in my manuscript, but I didn't talk about it in the talk because time is limited. So Sichuan is not just a case for me. Sichuan is very special in terms of its relationship to extraterritoriality. So for Christianity, um, Sichuan was a place where there were it was like a center for Catholics during the Qing dynasty because of the Yongzheng Emperor's prohibition of Christianity in 1727. So after that, many Catholics, missionaries, and Chinese adherents, they moved to Sichuan. And that's why there were Sichuan. There were so many legal cases of foreign Catholic missionaries intervening on behalf of their Chinese converts. You don't see that kind of density of cases in elsewhere, not in Shanghai, because Shanghai was not like a haven for Catholics, but Sichuan was. And the second reason I chose Sichuan is, so the second part of my book, in addition to this Christianity part, is about the commercial disputes. So it's about how foreign merchants take Chinese merchants under the protection of extraterritorial regime. So the second part is about about this legal interactions after Chongqing became a treaty port, and Chongqing became a treaty port in 1890s, and it was the I think it was the latest open treaty port in China, and it was also the innermost treaty port in terms of its location. So I'm really interested in understand how this interior environment, interior society, inner frontier society shape the practice of extraterritoriality. So yeah, so in this regard, Sichuan is quite special.
I may have a very short follow-up
Sure.
question. I'm just very curious about how is this term extraterritoriality expressed in Chinese or by the locals? Were they even aware?
治外法权.
So even during the late Qing,
Yeah,
the
even
laymen
yeah.
they would know the 治外法权.
Depends on who you call layman.
I mean, people without proper education or proper legal training.
Oh.
How do they perceive that?
Good question. So in official records, officials, magistrates, when they were describing this kind of abuse, they would say it's the abuse of 治外法权. But for people who are not educated, they probably don't know about the term 治外法权. So instead, they would use the term I just used, 包揽词讼, 教士包揽词讼. Yeah.
If I may, I would like to push a little bit on actually the including interpretations that you make, and particularly the point about this whole legal system within a legal system, which, as you say, it kind of feels like a sort of legal vacuum. Like it's not the traditional legal system is not really meeting all the needs, all the legal needs of its citizens. So. What I'm actually wondering is, well, this is a privileged legal system within the legal system because it grants converts a privileged or faster or more efficient access to resolution. And from the perspective of non-converts, it seems to me that this is well, there's two questions here because from the perspective of non-converts, it seems like outright corruption. It could be interpreted as just a system within the system where if you agree to the terms of the club, which we could call it roughly, you will get privileged access to legal solutions. If you don't, then you're kind of screwed, then you're more vulnerable. So my question is, I don't think you raise it enough in sort of like the concluding considerations, the point about what actually makes this possible. And I think that's kind of similar to the second question about the French state, is that these are powerful merchants, missionaries, networks. The potential for violence is enough of a deterrent, I guess. It doesn't have to be enforced all the time to actually serve as a reason for local courts to say, okay, let's treat this with preference. So that's just, I guess, just a comment, and come back on that. But I think the more concrete question I had was about maybe I missed something, but what was the what is the difference that explains the Catholic and the Protestant, the difference in how they're
Okay.
how they're present in Sichuan at that
Yeah.
time?
So first question about difference between Catholics and Protestants. So the Catholics came to Sichuan a long time ago. They've been in Sichuan since the 1700s. So they're quite established. And they were also prosecuted and they were bullied during the long 18th and 19th century. So they hold a lot of grudge against local communities. So when they gained extraterritoriality and other power, they acted quite aggressively, especially the Catholic missionaries, because they were actually quite vulnerable during the earlier time. So Catholic missionaries, they would often engage in a combative, act in a courtroom. Like they were really aggressive, and there were a lot of criticism of Catholic missionaries and Chinese Catholics in local accounts. However, the Protestants they arrived in Sichuan in large number only since the 1870s and 80s. So when they arrived in Sichuan, there was already this very strong Catholic presence. And they also understood that because of the Catholic missionaries' rather aggressive abuse of extraterritoriality, there were a lot of hostility toward Christianity in general, and they're trying to distance themselves from the Catholics who abused extraterritoriality. But they also have to use extraterritoriality to attract converts because they have to compete for converts with the established Catholics. So I would say the Protestants, I mean, in written records, they would say, oh, we're not going to interfere with Chinese judicial proceedings. We're not going to abuse extraterritoriality. But in reality, they did use that, but like in a more polite way. And also, mostly, they're not interested in religious matters. They're more interested in commercial disputes. Yeah. So that's the first question. The second question is,
What about the power of the backing of the state?
yeah, what made
Power,
this
the potential
possible,
for
right?
power?
Yeah, what made this possible? I think what made this possible is not only the power of colonial states like France and Britain. This is not the only reason that these abuses were possible. I think part of the pressure for the local magistrate actually came from the Qing court, the Qing imperial court, because they paid a lot of indemnities to France and other colonial powers because of the violence, right, against Christianity earlier. So the Qing imperial court gave a lot of pressure to local magistrate to tell them that you should make peace with the Catholic Church because we're not going to pay these indemnities. So yeah, I think at least 50% of the pressure came from the imperial court. So magistrate, they were actually between different power holders, and they were not themselves very powerful. So I think in the end, they worked out a solution, which is best for themselves. That is to accommodate the the requests and demands of those missionaries and converts. Yeah.
But what does the Qing court get out of this?
Some sort of stability to some extent, because the Qing state was dealing with other crises, like a lot of crises other than crisis about Christianity. They're really busy dealing with other crises. So yeah. I mean, the Qing state by 19th century is not a state that was functioning very well. It has a lot of problems. Yeah. Oh, thank you. So, the question about Sichuan, I think it's my answer is pretty much the same about the question answer to the question about regionality. So, Sichuan is quite special in terms of the Catholic presence. So, after the 1727 ban on Christianity, many of the Catholic missionaries and Catholic followers came to Sichuan. So there are a lot of Catholics. And elsewhere, you don't see the same type of density of cases in terms of Catholic missionaries intervening on Chinese Catholics. So in Sichuan, there are a lot of this type of
Are you
cases.
seeing the conversion? The
Yeah. Oh, this is not unique in Sichuan. This is happening everywhere. But in Sichuan, you have a lot of cases showing that. This is a trend that was mentioned, that was noticed in elsewhere of China where missionaries were present. For instance, Shandong, Joseph Asherick studies how Catholic missionaries intervened in the lawsuits of their Chinese converts. So this is like a general trend. But in Sichuan, you have a lot of cases.
And why did they flee to Sichuan after 1727? Why so many Catholics?
Oh, why? So first of all, it's because of the geographic remoteness of Sichuan. It's in the interior. It's very far from Beijing, and it's also very far from the coast. And second, it's because Sichuan was a migrant province during the 18th century. So during the Ming-Qing transition, there many of the locals were killed. So there were a lot of migrants coming to Sichuan. So in this way, Sichuan became a kind of a stranger society, and that provides an ideal shelter for people practicing unorthodox religions such as the Catholics, but also other people like the White Lotus. Yeah, in theory, yes, but we don't have a lot of Qing local archives in Guizhou, so empirically, we cannot test that question. Yunnan, yes, but we also don't have like a very rich body of local archives. So I mostly use the Boqun archives, which is the largest surviving archives from the Qing dynasty. But yeah, I think there are similar instances in Yunnan because there were also some French Catholics, but not so much in Guizhou. I don't know because yeah, I don't think there were like I don't think there were a lot of Catholics in Guizhou during that change. I mean, there are some Catholics, but not a lot.
I is use strategy.
Wow. Not in. Huh. I
Tell them that they replace
One contrasting case.
why is it not a strategy? I mean, it is a strategy found everywhere with Christian presence, but I mean, empirically, I don't notice that it is a trend in Beijing or Shanghai. Because in Shanghai, I mean, there are other ways of how people exploit the extraterritorial regime, right? In Shanghai, it's mostly the mixed court, and some Chinese, they would use the international settlements for for political refugees, right? Because it's extraterritorial protection. But I don't see a trend in terms of missionaries in Shanghai using extraterritoriality to convert people. I think it's probably because of the more cosmopolitan and urban context in Shanghai. Yeah. I wish I could answer your question, but there's no empirical data or record to substantiate my claims.
Yeah, sure.
'Cause I work with legal records in South Asia, and I know how hard it is to find the sort of court records that I presume you've had in the context of South Asia. So it would be really, when you were saying about that database, it's so familiar to me because you just find what you can find. So I
Yeah.
was wondering if you could just, is it that judicial records that you found in this particular archive, I presume they are very hard to find in the context. Is that part of the reason why it's such an important argument to make message crime, because you just can't find those judicial records in other contexts? Because that would be the similar in South Asia. I've heard that so many times, right? Like I found this gold mine because it's so hard to get to them. Is that similar here? Is that what you're looking at?
Yes and no. Yes, is that Boqun archives is the largest local Qing archives that we can find today, right? And there are a lot of these cases. No, it's because I mean, people normally do not study this type of Sino-foreign interaction in the interior. Yeah, most people, they would place extraterritoriality in the coastal regions, right? And study, like the institutional dimensions of this colonial regime. And I think in the interior environment where you don't have like pronounced colonial presence, and you don't have, established colonial institutions, I think it's important to understand how extraterritorial actually function in practice. And I think the interior case could present a comparative lens to what we have already know from the coastal regions. So I think the interior, in itself, it's worth investigating.
Yeah. Of the denominations, issue structure, it was to different denomination, we could have the communications between the missionary and the headquarters, like letters and reports. They are the same denomination. It's very good from the Western language data. You compare what is missionary, what he described the case in his work report to his headquarters, in what happened.
Yeah, thank you for the suggestion. This is definitely something I will go look at later. For instance, French archives that might present like different perspective from the Chinese archives. Yeah, it's just at this stage I have a lot of Chinese archives to process, but maybe later I will incorporate French archives into my study. Thank you.